Hello, citizens. Okay, imagine this. You've just cracked the UPSC Civil Services exam. You secured a top rank in the OBC category and you're ready to serve the nation.
You think your dream is finally real, but suddenly the government snatches it away just because your parent works in a bank, a PSU, or a private company.
Wait, what? They just cancel your rightful reservation because of where your parents work?
Exactly. They calculate your parent's salary, label you creamy layer, and throw you out. But what if I told you the Supreme Court just declared that entire bureaucratic trap completely illegal?
I need to know what happened. How many candidates lost their IPS or IFS dreams because of this?
Dozens, including Rohith Nathan and Dr. Ibsen Shah. But their fight just rewrote the rules of affirmative action in India.
So what actually happened to Rohith? He got All India rank 174, right? That's a massive achievement.
Huge, but here's the catch. His father worked in a private IT company, and Dr. Ibsen's mother was a junior clerk in a state PSU.
Okay, so they aren't high-ranking government officers, they are everyday working-class people.
Exactly. Under the 1993 Office Memorandum, income from a parent's salary is absolutely not supposed to be counted for the wealth test.
Hold on, salary doesn't count, then how did they get rejected?
Because of a controversial clarificatory letter the DoPT issued in 2004. Bureaucrats used it to illegally club the parents' salaries, claim they crossed the limit, and block them from top services.
That sounds incredibly unfair. You clear one of the toughest exams in the world and a random memo from 2004 ruins your life?
The candidates thought so too. They fought this through the tribunal and 3 high courts. The government lost every single time, but still dragged them to the Supreme Court.
Okay, let's get into the legal mechanics. Why was this 2004 letter so dangerous?
Because it tried to rewrite the law through the back door. The 1993 policy was a master document, created after the famous Indira Sahani judgment.
Right, Indira Sahani is basically the bedrock of reservation law in India.
Spot on. The 1993 policy explicitly shielded salaries from the wealth test. In administrative law, a mere clarificatory memo cannot override or amend a foundational master policy.
So basically, a clarification can only clarify. It can't invent brand new rules to penalize people.
Exactly. But the government argued they hadn't mapped the equivalence between PSU jobs and government jobs yet. So they claimed they had to use salary to calculate wealth under the 2004 letter.
Wait. You're telling me the government failed to do its own administrative homework and then penalize citizens for it?
That is exactly what they did. And the Supreme Court absolutely tore that argument apart.
I need to know what the judges said. How did they untangle this mess?
This is where the court drops the hammer on Article 14, the right to equality. You see, the government judged children of government employees by their parents' rank, not their salary.
Right, so a government clerk's kid gets the non-creamy layer status, even if the clerk's salary goes up over 20 years.
Yes, but a PSU or bank clerk's kid was being judged purely by their salary. The court looked at this dual system and called it hostile discrimination.
Because you're treating equally placed people, 2 clerks in different sectors, completely differently.
Precisely. The court pulled a brilliant precedent from State of Kerala v. N.M. Thomas. They declared that treating equals unequally is the very antithesis of equality.
Aha, so you can't create an artificial divide within the exact same social class.
Exactly. The state's failure to map job equivalence cannot violate Article 16 reservation rights. The court dismissed the union's appeals entirely.
That is a monumental win. Did they order the government to give Rohit and the others their rightful jobs?
They did. Within 6 months. They even ordered them to create supernumerary posts, extra jobs, just to accommodate the candidates they wrongfully excluded.
Wow. So for the millions of people listening whose parents work in banks, PSUs or private companies, what is the big takeaway?
Know your rights. If authorities reject your certificate using your PSU parent's salary, you now have a direct Supreme Court precedent to shield you. And for lawyers, it's a binding warning against executive overreach.
The creamy layer is finally reeled back into the Constitution. Drop a comment below, should PSU employees be treated exactly like government employees? And if this case shocked you, wait until you see our episode on the EWS quota on your screen right now. Stay informed, citizens, and stay curious.